Hi there, this is Chapter 12, Field Interviews, Arrest and Jail Searches, Lecture Video, Part 1. Let's start off by turning to your textbook on page 350, and you should have already read Chapter 12. You should have the PowerPoint open and your textbook with you. So page 350, Myths and Facts about Arrests and Detentions. Myths. If a fleeing felon fails to stop when told to do so, the police may shoot. That's not true. Facts. Police are allowed to shoot only if someone is in danger of imminent death or seriously bodily injury are likely to cause death. Myth. An officer is allowed to do whatever is necessary to prevent destruction of evidence. No. Fact. Police may not use methods that cause undue pain or in other ways shock the conscience or offend the sense of justice. Myth. The police may not detain a person unless there is probable cause to make an arrest. Fact. The police may temporarily detain someone for questioning if there is reasonable suspicion that the person is involved in criminal activity. It takes less evidence to establish reasonable suspicion than it does to establish probable cause. Myth. The police have the right to automatically frisk anyone whom they detain. Fact. The police have the right to frisk, pat down outer clothing for weapons, only if the officer has reasonable suspicion that the person is armed. Myth. The police need an arrest warrant to make an arrest for a crime that was not committed in their presence. Fact. Police can make felony arrests based on probable cause, even if the crime did not occur in their presence. In most states, they need an arrest warrant for misdemeanor arrests that was not committed in the officer's presence. Myth. When there is no emergency, police are required to obtain arrest warrants. Fact. The only time the Supreme Court has required police to obtain an arrest warrant is when they will enter a dwelling to make the arrest. So that clears up some of the myths. Let's look at slide 5 of your PowerPoint lecture. Right to use force. Force must be reasonable to effect arrest or detention. Force should be proportional to the threat that is faced. Non-deadly force is also limited, but has fewer restrictions than deadly force. Factors to consider: the person, the appearance, and the force used. Tennessee versus Garner, slide 6. The police shot a suspect fleeing the scene of a burglary. Police were aware that he was unarmed and nonviolent. Supreme Court placed limits on when deadly force may be used. A fatal shooting is the ultimate seizure under the Constitution. Police should use deadly force only when the totality of the circumstances lead them to believe it was necessary. Suspect should be an immediate physical danger to the officer or an innocent civilian. Look at page 351 of the textbook. What should be considered before using physical force for an officer? Factors that must be considered when using physical force: a reasonable person, reasonable appearances, reasonable force. Factors that should never be considered: getting even, revenge, retaliation, teaching them a lesson. Go to slide 7. Graham versus Connor. Graham was a diabetic, arrested, and sustained multiple injuries when the police took him into custody. They applied the objective reasonableness standard to all arrests and do not have to show that the harm was intentional or malicious. Slide 9, reasonable level of force. Regarding the person, it varies depending on the suspect and the police officer. Look at page 352 and read on your own reasonable appearances and reasonable force on page 352. As to the appearance of danger, a perception of danger may enable the use of more force, even if a real danger is limited. An example to that might be someone who had a gun that appeared real but really wasn't. Maybe it was a BB gun or a pellet gun, but it appeared real. That's the perception of danger. As to the force itself, deadly force only if the police or public are in danger of death or serious injury. Any force must be reasonable. Look at page 354. Actually, before we get to that, let's look at page 353. Criminal charges for using excessive force. A force that is beyond the the reasonable use is called excessive force. This is an important distinction because an officer can be charged with criminal conduct if he or she uses excessive force. If the excessive force results in death, the officer can be charged with manslaughter or even murder. Impermissible methods of obtaining evidence. Roshan versus California, about halfway down through the paragraph. Roshan attempted to swallow the evidence. The police responded by having his stomach pumped. The court held that this procedure was very painful and could not be tolerated in a civilized society. Look at page 355 of your textbook. Second paragraph, although the court has not totally ruled out the use of surgery, it established a balancing test. Surgical procedures that pose any threat to the suspect's health cannot be done. The prosecution must show a compelling need for the evidence. If there are other witnesses who can supply the needed information, surgery is not a reasonable alternative. Surgery also would not be allowed if the facts indicate that there was a high probability that it would not be possible to conduct conclusive tests on the evidence once it was recovered. High-speed police pursuits are dangerous and occasionally result in fatal accidents. The Supreme Court ruled that reckless driving by the police does not raise constitutional issues. Due process is implicated only if the officer intentionally tried to cause harm unrelated to the legitimate objective of arresting the suspect. So, it is possible for officers, for the prosecution to obtain evidence from a defendant, such as an expended bullet that's in their body. But it has to be looked at by the court as to the value of that evidence and if the procedure itself would not cause a threat to the defendant's life. Look at page 354, and you should read Table 12-1, the analysis of appropriate use of force. So read that for yourself, Table 12-1. Slide 10, force and detention of suspects. Detention, force used to effect an arrest is based upon the probable cause for arrest. Crime, victim, and total circumstances are important in the detention. Excessive force could result in criminal charges against the police, as stated before. Excessive force could result in a civil lawsuit against police. A field interview, which will be covered more in toward the end of this chapter, in chapter 13. Field interview, the police briefly detain a suspect to question them. Look at page 357 of your textbook. Table 12-3, comparison of field interview and arrest. So let's look at that. The grounds to initiate contact. A field interview is based on reasonable suspicion. Reasonable suspicion is sufficient facts that would make a reasonable officer believe criminal activity is afoot. Custodial arrest, arresting someone, taking them into custody, is based on probable cause. Probable cause is sufficient facts to convince a reasonable person that a crime has been committed and this is the person who did it. Warrant requirement, none for a field interview. For a custodial arrest, arrest warrant is mandated when the officers will enter a home to make an arrest unless the emergency exception applies. Many states require an arrest warrant for a misdemeanor not committed in the officer's presence. Miranda warnings. Miranda warnings are not required for field interviews. For custodial arrests, Miranda warnings are mandated for all questioning after the person is taken into custody. Right to use force. Field interviews, officers may use reasonable non-deadly force to detain the person. Officers are restricted to the lowest level of force that will contain the situation. Deadly force may be used only if there is imminent danger to the life of the officer or a bystander. Right to use force for a custodial arrest. Officer may use reasonable non-deadly force to arrest a person. Deadly force is never authorized to make a misdemeanor arrest, but officers may use reasonable force in self-defense. For felony arrests, deadly force is justified only if there is imminent danger to the life of the officer or a bystander. And length of stop. For a field interview, brief detention in order to ask the suspect questions. At the end of the questioning, the officers must decide whether to make an arrest or release the suspect. Length of stop for a custodial arrest. Once the arrest is made, the officers may take the necessary time to secure the scene and complete the necessary paperwork. The suspect is then transported to the station and is booked.